All stand. Coronial Courthouse stands received. Please be seated.
Superintendent, following on from what I was asking before the break, in terms of the release of that retention device, you set this out in your first statement on the 13th of March 2020 and note that at 7:13:35 p.m, Constable Rolfe can be seen on Constable Kirstenfeld's body-worn video disengaging the initial retention devices on his holster. And just a reminder, this is at house 577, the first house that the officers go to. He disengages the initial retention devices on his holster and a click consistent with that action can be heard. You note this indicates preparation for a fast draw of the firearm. Now in court, and I say this by way of warning as well, because I'm going to ask the Superintendent to demonstrate what that action is in terms of disengagement, and we have in court, it's agreed between the parties, an example of the holster that Constable Rolfe would have been wearing and what's known as a blue gun, which is a plastic gun, which I can assure everybody is not a real gun and is not and has never been capable of firing any bullets, but it sits within the holster. If you could just hold that up, Superintendent Barron. And does that holster, is that consistent with what you're talking about, one that has a number of engagement devices? Or?
Yes.
So can you indicate, you describe it I think as a 3-step process of taking a gun out of the holster, is that right?
Yes.
Can you go through those 3 steps slowly?
All right, so step 1 is you depress this hoodlock switch. Step 2, that gets rotated forward. And then step 3, there's a switch in here that must be moved backwards slightly before the gun can come out. So it's that switch there, which you use your thumb to manipulate. Right now the gun can't come out. Once that switch is pushed back, the gun can come out.
And this might sound an obvious question, but what's the purpose of having the 3 steps to remove your gun?
To make it more difficult for an offender or someone trying to get the gun out to use it against you.
For a trained police officer, is it actually quite a quick process to go through those 3 steps?
Yes, it is.
And is it part of your training to learn how to go through those 3 steps within a second?
Yes.
But for a member of the public not familiar with that retention device, is it difficult to remove that gun from the holster?
Yes.
In terms of what you saw on the body-worn video footage of Constable Kirstenfeld, you described that at 7:13:35 seconds, Constable Rolfe can be seen disengaging the initial retention devices on his holster.
Yes.
Are they the steps 1 and step 2?
Yes.
And then what did Constable Rolfe do as he moved through the house in terms of the position of his hand on the holster?
Well, so the hood was forward and he had his hand gripping the grip of the firearm and his thumb resting on that 3rd switch or that 3rd movement.
So there was only the 3rd movement to go before the gun was drawn?
Yes.
And it's that you indicate was indication of, or that you say in your statement was indication of his preparedness for a fast draw of the firearm?
Yes.
Was that move appropriate as he continued through the house of 577?
I don't think so, and it's certainly not what is trained.
We can put that down now for the moment, and somebody else might ask you any questions about it. You, of course, have to give your statements and, in fact, give your oral evidence prior to hearing a version of events from Constable Rolfe, correct?
Yes.
And Constable Rolfe, this is not a criticism, but didn't participate in a record of interview where he provided a version, is that right?
Correct.
So it wasn't until the trial that you get to hear his full explanation for what occurred, is that right?
Yes.
So I just want to put to you then some of the evidence that Constable Rolfe gave about this issue in trial. Mr. Edwardson was asking him questions on the 3rd of March 2022, and this doesn't need to come up, but we can do if Beck likes. It's at page 1057 of the transcript. Mr. Edwardson says, I want to ask you a couple of questions, if I may, about your hand position in relation to your Glock, referring to House 577. He asks Constable Rolfe, can you explain what we see there? And Constable Rolfe says, what you can see there is me placing my hand on my Glock in its holster and using my thumb to release the first retention device on that holster. Mr. Edwardson asks, how many retention devices are there on that particular holster? Constable Rolfe says, technically there are 3, but there are only 2 devices that require any action by us to release the Glock. There is one static device. So there was a bit of confusion by Detective Senior Sergeant Barham in his description of it. There's one static device that we don't interact with at all. It's a guard at the front of the holster, which can be seen. He's asked, so what did you actually do? And he says, so the retention device that I released requires downwards motion and forwards motion. So 2 actions in one fluid movement to release. That's what you described as step 1 and 2, is that right?
Yes, and that's what the manufacturer describes as well.
Was there any confusion on your part?
No.
He goes on to say, so I placed my hand on the Glock and pushed down. A device pushed it forward to release that first retention device from covering the rear of my Glock. And Mr. Edwardson says, for the jury's consideration, can you please explain why you did that at that point in time as you moved effectively through House 577? And Constable Rolfe says, and I'll just ask you to consider this to see whether it affects your evidence, Superintendent. He says, we are trained, in training, we train to prepare for a potential threat or a potential situation, which was described as if-then thinking. So at that time, clearing that house or searching through that house, I was wearing for a violent offender, I was looking for a violent offender who had just days previously in that same house attacked 2 police officers with a potentially lethal weapon. So all I was doing was preparing for if I was presented with a case where I had to follow my training and utilise drawing my firearm, depending on the situation I was presented with. And Mr. Edwardson says, in other words, it was a state of readiness. And he says, correct. Is that evidence, in your expert opinion, a justification for removing the retention device, or steps 1 and 2?
No.
Why is that?
Our training is to keep those retention devices in place for your safety and everyone else's until you've decided to draw the firearm.
What Constable Rolfe seems to be explaining is that in training, he was trained to prepare for a potential threat, and it was described as if-then thinking. And so he's effectively saying that it's a state of preparedness that was put to him, or readiness, as Mr. Edwardson described, that if Kumanjayi came armed with a weapon, then he would be better prepared if he released those steps 1 and 2 on his retention device. Is that acceptable?
Obviously, if-then thinking is part of the training, but I don't think that was a good application of if-then thinking.
Sorry?
I don't think that was a good application of if-then thinking.
Did it in fact increase the risk at all?
It increased the risk of Constable Rolfe being able to be disarmed by Mr. Walker or someone else.
And to your mind, did it increase the likelihood of the use of that weapon if Kumanjayi presented suddenly?
Yes.
Can I move now to House 511? You set out the movements of Constable Rolfe and others in your statement from about paragraph 74. I beg your pardon, 75. Sorry, just before I move on from House 577, the conclusion you reached at paragraph 74 was that the forced entry search of House 577 was not reasonable or necessary and is a departure from police training, practice and procedure. Constable Rolfe moving through the house with his hand on his firearm and the holster disengaged is a disproportionate use of force, and not appropriate in the circumstances, given it was known there were young children in the house. Do you stand by that opinion?
Yes, I do.
A police officer is trained to consider the fact that other citizens are in the near vicinity when they're thinking about the tactical tools that they'll use?
Absolutely. And if you're considering the use of a firearm, you certainly have to take into account anyone that might be standing behind the offender.
And I'll come to that issue shortly, but the fact of the presence of children in the house, is that something that police officers would be trained to be aware of?
Of course it is. If that was your house with your 12-year-old playing PlayStation, do you think that would be acceptable for police to do? I don't.
You note in your statement that at paragraph 75, once they'd completed the search of the house, they left to attend the second location as indicated to Constable Rolfe by a member of the community on that map, and that was by Mr Robertson. At approximately 7:17, they arrived in the vicinity of house 511, that's the red house, now known as Memory House. Constable Rolfe activated his body-worn camera at this time, which back captured 30 seconds of footage. Some of the police members began questioning people in the area regarding the whereabouts of Kumanjayi and Rakisha. At 7:19 p.m, Constable Rolfe jumped over the fence, despite there being a gate in short distance away. Was there anything significant about that you noted?
Yes. Could be seen as disrespectful because anyone that's worked any time in the Central Desert knows that a lot of the time beds and bedding are placed in the backyard and people sleep outdoors. So the entire yard is, I guess, an extension of a bedroom.
So you're entering into someone's home without permission at that point?
Yes.
He spoke to a female with the surname Lewis, and you set out the conversation that he had with her at paragraph 77. Effectively, Constable Rolfe was asking her a series of questions that it included, and I won't use Kumanjayi's name, of course, we're here to grab up Kumanjayi, hey. And he asked, where's Kumanjayi, where's Rakisha? And she told him, I don't know, I'm a visitor. You set out the conversation captured on the body-worn video.
Yes.
After that, Constable Rolfe made his way around the side of the house and he was approached by Constable Eberl, who confirmed with Constable Rolfe the name of the person they were looking for. That is, that it was Kumanjayi. And Constable Eberl said, someone just went in the back room here. And that was captured on Eberl's body-worn video at 7:20 and 19. Both officers went to the front corner of the house with Constable Eberl moving towards the front door while Constable Rolfe spoke to a child and a woman who were in the yard. Constable Rolfe had a conversation with someone we know now to be Leanne Oldfield. Constable Rolfe said, hey missus, where's Kumanjayi at? Leanne said, I don't know. Where's Rakisha today? Leanne said, I'm not from here. And Constable Rolfe said, righto, whose house is this? And we can hear on the body-worn video a reply, Margaret's, but they still in, and then the reply is, can we go inside because we're looking for, and Leanne Oldfield says, go, and then something that can't be heard. Is that right?
From recollection, yeah.
Do you recall seeing it that there was a gesture that Leanne was making at the time?
Vaguely.
Was that sufficient? Somebody whose house it wasn't, that is indicating it was someone else's house, saying go, and then obviously words after that, that's not sufficient permission to enter into that house, is it?
I don't think so.
Constable Eberl said to a man sitting outside in the front yard, and that was Nathan Coulthard, so you don't know who else is in the house? And he said, I don't know. And that's captured on Constable Eberl's video at 7:20 and 39. I'm reading from paragraph 81 of your statement. Constable Rolfe then proceeded towards Eberl, who was at that point standing approximately 2 metres from the front door of house 511, which was open. Constable Rolfe's body-worn video records that at 7:20 and 54 p.m, he transmitted on the police radio stating, me and Adam are just going to clear this red house. The concept of clearing a house, is that one taught to Northern Territory Police?
No, it's not really. It's more a military thing.
You note at paragraph 83, in choosing to enter and clear, in inverted commas, a premises where they suspected Kumanjayi could possibly be, combined with their prior knowledge that he had previously armed himself with a hatchet when confronted by police 2 days earlier, these officers put themselves into a potentially very dangerous situation. With all the training they had received, plus their combined experience as police officers, it would be reasonable to expect that they should have realised the potential danger. They either didn't perceive that risk or they chose to ignore it and instead chose to conduct a forced entry search, which policy states is to be avoided and should only be used as a last resort. You stand by that opinion?
Yes.
This was not a last resort and instead appears to be the first or preferred option.
Yes.
That's evident, isn't it, not just from the entry into House 511, but the entry into House 577 previously?
Yes.
You go on to note that precipitated the confrontation with Kumanjayi, and that could have been avoided if the officers had followed standard police procedure of cordon and contain.
Yes.
Those officers ignored training, policy and procedures, which states that the emphasis will always be on the avoidance of conflict where possible.
Yes.
You stand by that opinion.
Yes, I do.
And you note in your statement that clearing a house constitutes a forced entry search. Correct?
Yes.
In terms of avoiding conflict, you note that prior to attendance at an incident, officers should thoroughly analyse all available information and evaluate the full potential of the situation in order to avoid any potential confrontation. This can be done by the correct use of tactics coupled with communication skills. Putting aside the fact that going into this house by forced entry at that time was not consistent with the 5 a.m. plan, which I want to circle back to, if the officers assume the plan didn't exist or the plan had changed for some reason, when the officers got to that house and saw that someone had entered into the house, what should they have done?
Well, standard training and the polite thing to do would be knock on the door, announce police here, can you come and talk to us? Or some similar words.
You point out at paragraph 89 that no one positively identified to police that Kumanjayi had gone into the house.
Correct.
And you also note that in Ebel's statement, he says, I had a look in the house. I seen someone go to the back and shut the door. So I said, I knew someone was in the house. I didn't know who it was. They were told that house 511 was Margaret's house, but she wasn't present and they did not have the householder's permission to enter into the house.
That would appear to be the case.
In terms of actually the situation they found themselves in, you note that the circumstances around House 511 in Yundamu were not significantly different to the circumstances that the group of police officers found themselves in at Walpuri Camp on the 7th of November, and yet a completely different decision was made.
Yes, I did draw that comparison.
Appropriate decision on the 7th of November, consistent with the ICENCIA training and the operational principles, and a decision on the 9th of November, which was not consistent with the ICENCIA principles and training.
Correct.
In terms of a risk assessment, which is principle 2 in the 10 operational safety principles, you note at paragraph 94 that little, if any, risk assessment was made of the risk of entering a force or confrontation, or the fact that Kumanjayi could be armed.
Yes.
And there was no planning process or discussion prior to entering House 511.
No, did not appear to be.
The evidence that we've heard to date suggests that there was a discussion of a cordon and containment to the extent that is a loose cordon around the house. Does that constitute a plan and a risk assessment?
It constitutes a cordon. Whether or not that's part of a plan, I don't know.
Was that sufficient risk assessment for this situation for Kumanjayi?
Well, risk assessments can be either formal and written or informal and ongoing assessment, so I can't say exactly what was in their minds.
You note that there's no circumstances that made it impractical to adopt a cordon and contain approach in that situation, and that the ICENCIA plan should have been implemented. What did you envisage there?
That they would have cordoned the house and let Sergeant Frost or other police know, and got as many resources there as they could whilst they maintained that cordon and isolated the person that was in the house. Contained the person that was in the house and isolated the house from anyone else.
So we've heard some evidence to the effect that they were limited compared to the 7th of November because they only had the 5 police officers there, the 4 members of the IRT plus the dog squad member. Your point is they could have called on local members for assistance at that time?
Yes.
If they had reasonable belief that Kumanjayi was in the house?
Yes.
In terms of going into the house in that small space at that time of night, after 7 p.m, when it was darker, what do you say about that, given the risk assessment or lack thereof?
It was a risky move to go into the house.
What were the particular risks as you see them at that time?
Low light conditions, which is a known condition of danger to police, that you can't see as well, even though you do have flashlights, etc. The risk that they didn't know who was in there. They didn't know anything about what potential weapons were in there. Going into any house, a house has a multitude of weapons, for example, kitchen knives that can be used, or many other improvised weapons. So going to the house at all was a risky manoeuvre, and our training says should have been avoided.
You note that at 7:20 and 57 p.m, this is paragraph 106 of your first statement, while still in the threshold of the front door, Ebel's body-worn video shows he turned on his torch, which illuminated the front room and showed a male person can be seen on the other side of the room, who was unseen at that point due to the darkness inside the room. Prior to entering, a number of options were still available to the police members, such as knocking on the door and asking the person they saw to come and talk to them, or if the person reacted violently, closing the door and containing the person inside the house, then applying the I Sensia plan to the incident and attempting to negotiate a peaceful solution. Based on their training, Rolf and Ebel should not have considered entering the house a reasonable tactic at that time. You stand by that opinion?
Yes.
At 7:21 p.m, Constables Ebel and Rolf entered the front room of the premises via the open front door. Neither officer appeared to notice that the male in the front room had his right hand in his pants pocket, possibly already holding a weapon. Or if they did notice, they didn't take account of it and did nothing to mitigate this potential danger. What's the training with respect to looking for offenders' access to pockets?
Well, you want to be able to see an offender's hands, because it's their hands and what their hands are holding that are going to harm or kill you. So the reasonable response in that circumstances, the first one would have been, stop where you are, show me your hands. They didn't do that. They closed distance with him.
You note that Ebel immediately began questioning the male as to his identity. The male attempted to leave and tried to brush past the police officers. Constable Ebel stopped him by placing a hand on his chest, saying, "Stop there, stop mate. We're just asking you questions, no need to keep walking." Kumanjayi provided a false name of Vernon Dixon. Constable Rolf guided him to a position with his back to a wall next to the open front door. We see on the body-worn video, and I won't play it again, Constable Rolf unlocking his phone to access the photo he had of Kumanjayi on it. One of the police outside asked via radio if they were at the front of the red house, and Ebel replied, "We're just inside the front door, mate. Stand by." You note Constable Ebel did not relay the presence of a person inside, or that they were actually speaking with someone they suspected might be Kumanjayi. What should have happened then?
Communication that we think we've potentially got him here, and potentially, given the knowledge that they had of him, that potentially he was armed, that a couple of days ago he had armed himself. We're taught to maintain a minimum of 6 metres distance from someone that you suspect might be armed.
Sorry.
So they could have or should have made considerable distance from him, or If they were going to stay there, they should have taken firm control of both of his arms
What's the purpose of the 6 metre distance?
to give you a bit of time and distance to react and move back further if required, or do whatever else is required.
In terms of the circle that we saw with the tactical options on the outer perimeter, does it increase the number of options you've got if you maintain that distance?
Yes.
You note, just before I move on from that paragraph, that the failure to communicate the information that we had demonstrates the lack of effective communication and coordination between the team members and the lack of any effective leadership or plan of action. And that's not consistent with the training that Northern Territory Police get. Is that right?
Correct.
The next thing that happened was Constable Rolfe holding his phone with a photograph of Kumanjayi on the screen next to his face to make a positive identification. Constable Rolfe, either officer appears to say, "Easy, mate, easy," and this appears to indicate a positive identification of Kumanjayi was made. Your opinion is that closing the distance between the officers and the subject without any kind of subject control is poor practice and against training. Why is that?
Because his arms were unrestrained, he was able to do whatever he wanted with his hands and arms. They put themselves into potential striking distance, even though they had intel that he'd previously armed himself. It's just poor tactics to be that close to someone and not have an effective control. Had they both grasped his arms firmly or decided you are now under arrest, said that, and taken control of one arm each, that would have mitigated the risk to an extent. But they didn't do any of that.
So you say they shouldn't have been in the house in the first place. If they were in the house, they shouldn't have put themselves in that close proximity.
Yep.
But once they'd done that, if they were going to do that, at least mitigate the risk by taking control early.
Yes.
You note that it's a breach of the principles used to minimise force, which we went through this morning, which start with staying alert, maintaining a safe distance, always watching the subject's hands, anticipating problems, identifying behavioural warning signs, expecting the unexpected, being aware of surrounds, putting yourself in a position of advantage, not becoming complacent. Those principles I've just read through 1 to 9, are they drilled into recruits when they're going through their training?
Yes.
And are they reinforced in training each year?
Yes.
So in terms of the options available to them at that time, noting that they'd put themselves in a dangerous position, paragraph 114, you say, given the prior knowledge that Kumanjayi was a flight risk and had previously grabbed a hidden weapon, they should not have closed in rapidly and I withdraw that. They should have closed in rapidly and taken firm control to ensure that he didn't escape. Had they done that and taken effective control of one arm each, an arrest could likely have been made without further incident. The other tactical option available to them was tactical disengagement. They were positioned right next to the opened front door. 1 or 2 paces would have taken them back outside, and there was nothing between them and the door to impede their exit. They could have contained him inside the house by staying a short distance and by closing the door on exiting, and that would have given them the distance to implement the I-Sensia plan.
Time, distance and cover.
Could you excuse me one moment? I'd just ask Beth to play a portion from Spotlight where we see Constable Rolfe give an explanation of why you might be wrong with the I-Sensia, and then I'll ask for your comment.
Yeah, so Barron was utilising a model for a planned police response for a siege situation, a siege, a barricade situation, a hostage situation. He was utilising the model for the planned police response for that and trying to overlay that onto this incident, which it's not relevant to. That's where he was using, it's called an acronym called ISNSIRE. isolate, contain, evacuate, negotiate, conclude, investigate, rehabilitate, evaluate. That is the acronym for a planned police response for a siege situation. He overlaid that to a situation where it wasn't relevant. That's where that came in. And then he's tripped himself up because he has made 6 statements. So he's said different things. He said the first shot was justified, but he said after the first shot was fired, Kumanjayi was incapacitated. Therefore, I shouldn't have fired the second or third shots. He's then said in another statement, the first shot is justified. After I fired the first shot, I should have used my taser. Now, the way I was trained, I'm only legally allowed to use my taser when I fear for immediate serious harm for myself or another person. So immediate serious harm. To utilise my Glock, I can only utilise my Glock when it's the last option, but I fear for serious harm or death to myself as a potential outcome. So there is an overlap in the legislation, but obviously your Glock is the last option. So he said in one instance that Kumanjayi is incapacitated, and then he's said that he still potentially has the ability to cause serious harm. So he has just said what he's just gone down the narrative that the NT Police executive are pushing, and he was willing to assist them in pushing their narrative. And he got tripped up. At some point after he started making their statements, medical evidence has come through that has shown that the first shot was not incapacitating in a medical sense. And in fact, the second and third shots were not incapacitating to Kumanjayi's right arm. So I believe along the way he's changed his story, and I think he was just willing to toe the line by the executive, and it all got a bit sticky for him, and he was out of his depth.
I'll ask you later whether it all got a bit sticky for you, Superintendent Barrowman, whether you're out of your depth. I want to focus on the first thing about the I-Sensor. According to Constable Rolfe, you got it wrong, and the I-Sensor didn't apply in spite of the fact that it sits on your notebook as we went through and it's part of the training. What do you say about that?
He's completely wrong. It even says it in the training manual that it was originated as a siege response, but that it is applicable and scalable to just about every incident the police attend.
And it was applicable to this incident, is that right?
Yes.
So you've pointed out what the 2 tactical options were, either to take control at that point in time, this is prior to the first shot, take control, or to tactically disengage. What happened after that? You set out from paragraph 116. The officers persisted in their attempts to grab Kumanjayi. The officers still had the option to disengage or to go to another tactical option, such as a baton, OC spray, or taser. Due to Constable Rolfe not having effective control of Kumanjayi's right arm, this allowed Kumanjayi to obtain a pair of scissors with his right hand. It appeared that those scissors may have been secreted in his pants pocket, and Constable Rolfe's body-worn video footage indicate that Kumanjayi first produced the scissors at 7:21:56. He used those scissors as an improvised weapon. He used those scissors in a downward stabbing motion at Constable Rolfe at 7:21:57 p.m. And you note that we see on the body-worn video, Constable Rolfe raised his left arm to ward off the strike, which may have deflected the downward trajectory of Kumanjayi's strike to some extent. However, it appears from the body-worn video footage and from the resultant wound to Constable Rolfe's left shoulder that the movement did cause a stab wound to Constable Rolfe. At any time prior to the stab wound, well, I'll withdraw that. If the officers had moved back, as you suggested might be one of the tactical options, the tactical disengagement, this is prior to Kumanjayi producing the scissors, they would then have been positioned right next to the open door. 1 or 2 paces would have taken them back outside. There was nothing between them and the door to impede their exit. They could have contained Kumanjayi inside the house by staying a short distance from the doorway or closing the door on exit. This would have allowed some distance between them and Kumanjayi. If they'd exited and left the door open, would that have given those officers more of an opportunity to use a tactical option such as a baton, OC spray or taser if Kumanjayi produced the scissors?
Yes.
From the point at, we know they didn't do that in terms of the tactical disengagement. From the point at which Constable Rolfe was struck with the scissors, did he have a limited number of options available to him to protect his life and Constable Ebel's?
Yes.
You note the body-worn video footage shows Constable Rolfe lowered his height and moved backwards, and it was unclear whether that was a result of the force of the blow or his attempts to avoid the blow. You say at paragraph 121, best practice at that point, as taught and practiced in police defence training tactics, would have been to yell knife, knife, knife to alert and warn his partner in other police in earshot of the presence of an edged weapon. That didn't occur. His actions in not verbalising heightened the risk to Constable Ebel by limiting his opportunity to consider his tactical options. It appears that Constable Ebel was not aware of the presence of the scissors. Had Rolfe yelled knife, 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 it most likely would have prompted Ebel to disengage from the wrestle with Kumanjayi, thus removing him from the immediate danger. Police are taught early in the recruit program to maximise distance when a knife or other weapon is informed, and it's reiterated through defensive tactics and firearm training and requalification. You stand by that opinion?
Yes.
Are police also taught to yell knife, knife, knife if an edged weapon's produced?
Yes.
And that's for the purpose of alerting the other officer who's there and anybody else?
Yes, and potential witnesses as well.
Those two officers, in terms of confronting the threat, had their combined skill and presence and tactical options in terms of dealing with the threat. Is that right?
Yes.
And do they need to think about it as such, that they're a team there working together?
Of course they do.
You note when Rolfe was moving back and drawing his firearm, the struggle between Constable Ebel and Kumanjayi continued past Constable Rolfe to the point that Constable Ebel and Kumanjayi had their backs to Constable Rolfe by the time he drew and presented his firearm. Did that present a particular risk as you were assessing it?
The fact that he had his back?
Yes.
No. Oh, well, potentially a risk to Ebel because he was still within reach.
You say at that point Constable Rolfe had the option to draw his taser, spray or baton instead of his firearm. However, police training is that these other weapons are not the best option when an edged weapon's involved due to the potential lethality of the edged weapon. Does it depend in those circumstances, consistent with your evidence previously today, on the particular circumstances?
Yes.
Police are taught to draw their firearm in response to an edged weapon to provide lethal cover, and once the lethal cover's in place, police can then consider the use of less lethal tactical options.
Yes.
If the situation permits it, consistent with the training, any less lethal option should be used than a gun. Correct?
Yes.
At no point did, I would draw that, if police pull their gun so that they've got a tactical cover or a lethal cover, should they be saying something at the time?
Yes, police drop the weapon.
At any time prior to Kumanjayi being shot, could you hear Constable Rolfe warning Ebel of the presence of an edged weapon or a knife or scissors or anything?
No.
At 7:22, Constable Rolfe's body-worn videos show he has his firearm drawn and a double-handed grip on it. You say at that stage Constable Rolfe was not in immediate danger from Kumanjayi because Kumanjayi had his back to Constable Rolfe.
Yes.
The footage shows Constable Rolfe maintaining a right-handed grip on his firearm and using his left arm to brace against Constable Ebel's back. It appears that Kumanjayi was trying to slip out of Constable Ebel's headlock by moving forward, which also caused Constable Ebel to move forward towards Constable Rolfe. And Rearward, I beg your pardon, thank you. It appears Constable Rolfe braced his left hand on Ebel's back to halt his rearward movement. This appears, looking at it on video and even reading it, to be a very dangerous situation that these two officers are in with Kumanjayi? That is,
Yes.
all three of them are in danger at that time. Do you
Yes.
agree? Does that just reinforce what you've told us already, Superintendent Barham, that they shouldn't have been in that position in the first place?
Yes, it does.
At 7:22:01, Constable Rolfe fired shot one from his firearm, as indicated by the muzzle flash seen on his body-worn video footage. Shot one struck Kumanjayi in the middle to upper right region of his back, and that shot was not fatal. You note that Constable Rolfe did not use any dynamic verbal commands such as police, drop the weapon, or call on Kumanjayi to surrender or give any other warning that he was about to shoot. Should he have done, given the short time period that he had to react?
Yeah, there was potentially time for him to say something like that.
And would best practice have been for him to do that?
Yes.
Because that would have given Kumanjayi a warning and also Constable Ebel a warning.
Yes.
You note that had Constable Rolfe called on Kumanjayi to stop, there might not have been a need to fire the first shot if Kumanjayi had complied with a command. Are police taught to continuously reassess in a situation like that to see whether or not a suspect is complying?
Yes, they are.
You go on to note, though, that given Kumanjayi's prior to behaviour, it wasn't certain that he would have complied, and the delay caused by calling on him to stop may have been sufficient time for Kumanjayi to stab Constable Ebel, putting him in danger of death or serious harm.
Yes.
And we just don't know now what Kumanjayi would have done in those circumstances.
No, we don't.
And the police didn't know at that time.
No.
Constable Rolfe couldn't have known at that time.
Correct.
So your conclusion ultimately is that it is that Constable Rolfe had a defence to that first shot.
Yes.
Of defence of another.
Yes.
The first shot was fired at a time when the officers were upright, correct?
Yes.
What was the position of Constable, I would draw that, what was the position of Kumanjayi compared to Constable Ebel at that time?
Standing at his side.
I'm going to read to you some of the evidence that Officer Ebel gave in this inquest on the 17th of October, page 1791 from my friends at the bar table. Constable Ebel gave evidence that he was surprised even after the third shot that Kumanjayi had been shot. He was not expecting that. I read to him his first interview where he had said, I've heard a couple of loud bangs like boom, boom, that's what. And I was like, bloody hell, like had my gun gone off or what? Because it didn't, and I asked, because it didn't sound to you like you would expect a gunshot. And he said, yeah, that's right, yeah. It didn't occur to you that Constable Rolfe had fired in those circumstances? And he said, not at that point. And I asked, at the time of the first shot fired, you were standing directly behind Kumanjayi, correct? And he said, correct. That was his perception at the time. Do you now know where you were with the second and third shots? And he said, laying down down next to him. I asked, directly or on top of him? He said, kind of in the same position. I was sort of off to the side, but still holding his arm. And I asked, did it occur to you that your colleague would fire a weapon in those close circumstances? Firstly, when you were standing directly behind Kumanjayi, he said, no. I said, and then second and third, when you were directly behind him on the ground, he said, not from my perception, no. Do you think, looking back on it, I asked him, is it fair to say that you were centimetres away from Kumanjayi at the time the shots were fired? And he says, yeah, well, I was touching him, so yep. And I asked, do you think that in those circumstances there was a real risk that you could have been shot? And he said, potentially, yep. Superintendent Barham, drawing on your training and expertise, what do you say about the situational risk for Constable Ebel, given Constable Rolfe firing, firstly, the first shot?
Well, first shot, he was at extreme danger of potentially being shot himself.
Constable Ebel was.
Yeah, it was a very dynamic situation at that point.
And for the second and third?
Well, it was a lot more static, but again, had Ebel made a sudden movement to try and get into a better position, potentially he could have been shot then too.
Your conclusion in relation to the second, I withdraw that. That's fine. I think I will ask you about the second and third shot. You deal with this at paragraphs 141 to 142 of your first statement, the 13th of March. At 7:22:03, Constable Rolfe stood over Ebel and Kumanjayi, placed his left hand onto Constable Ebel's lower back and fired shot 2 into Kumanjayi's left side. At 7:22:04, less than a second later, Constable Rolfe fired shot 3 into Kumanjayi's left side in close proximity to shot 2. Constable Rolfe did not use any dynamic verbal commands or call on Kumanjayi to drop the weapon or surrender or give any of the warning that he was about to shoot. The Constable Rolfe did not say anything and fired both shots in rapid succession. Should he have been giving verbal commands after that first shot?
Yes.
You describe those 2 shots in rapid succession as being sometimes referred to as a double tap.
Yes.
Is that a technique that's taught by the Northern Territory Police?
Yes.
In what circumstances is it appropriate?
Well, it depends on the situation, and it's up to the officer's judgment. So sometimes one shot may be sufficient, sometimes more shots are required.
If lethal force is required to stop a threat, in some circumstances a double tap might be needed.
Yes.
And you note, firing multiple shots in rapid succession into the same target area on a person increases the trauma caused to the body, thereby increasing the chance of incapacitating the subject.
Yes.
Now, I know I'm dealing with this in a very clinical way, but I appreciate that those listening might be thinking of the loss of their loved one. So I just want to note, Your Honour, that we're conscious of that going through, and I apologise for how clinical this sounds in dealing with this technical evidence. When Constable Rolfe is asked about this in trial, in examination, in cross-examination, he said to Mr. Strickland of Senior Counsel, I'll find it for you in a break, Mr. Edenton, that there's a difference between a double tap and a controlled pair. Is a controlled, firstly, do you recognise that expression, controlled pair?
I do, but it's not in our training manuals.
Why do you recognise it?
Because I've read other police training manuals. I was a member of the International Association of Law Enforcement Firearm Instructors, so I've read manuals from other countries, other places, and it's a term used by them.
That's at 1096 for the benefit of my learned friends. And in any way, if this was being thought of as a controlled pair by Constable Rolfe, would that justify the use of force in shots 2 and 3?
No.
You say, paragraph 144, well, Northern Territory Police do train to fire multiple shots when necessary. You question the need for it in this situation. You believe Constable Rolfe had a number of viable tactical options other than to fire shots 2 and 3 because the circumstances had changed from those under which shot 1 was fired.
Yes.
What were the changed circumstances that meant that lethal force was no longer required?
Change in position of Mr. Walker. He went from being standing up to being lying on the ground with Ebel restraining him.
And in terms of Constable Ebel restraining him, you form the opinion that Kumanjayi's right hand was underneath him, is that right?
Yes.
I'm just going to read to you some of the evidence of Constable Rolfe because, of course, just to go back a step again, you were providing your written statements and your oral evidence prior to hearing from Constable Rolfe as to what his explanation was, correct?
Yes.
Constable Rolfe gives evidence at trial on page 1072 about what was going on as in terms of what he asked the jury to accept. And I'll just read from halfway down that page. After explaining that he was struck with a hammer-like motion and he realised that it was a metal blade, didn't realise it was scissors, he's asked by Mr. Edwardson of King's Counsel, when was the first time you realised that what in fact he had deployed through this exchange was the scissors? And Constable Rolfe said, not until I had him on his stomach. I was in mount and I was pulling his right hand behind his back. Mr. Edwardson says, so anyway, you saw what appeared to be a blade? He says, so I saw him holding a blade in a dagger-like grip, and then I had my shoulder up and my arm out to protect myself, and then he stabbed me in my left shoulder. And Mr. Edwardson said, right, and what did you do then? He said, instinctively from them I jabbed him just with my left hand, jabbed him in the face with my left fist. And then what were you doing with your right arm or hand? And Constable Rolfe said, instinctively at the same time, I put my hand on my Glock, at which point I realised his left hand was already on my Glock. So Constable Rolfe's indicating for the first time there that Kumanjayi's left hand was already on my Glock. And Mr. Edwardson says, can I ask you this? Were you aware in these split seconds, were you aware of where Ebel was and what he was doing and his proximity to this blade, which had just stabbed you? And he says, I was aware he was in close proximity. Question, so what did you do with your Glock? Answer, so as soon as I saw him with the blade, I immediately feared for my life. And I went for my Glock. His hand was on my Glock. And I twisted my hips back, which we're trained to do with speed, to knock that hand off my Glock and step back. As soon as I stepped back, Kumanjayi's focus turned to Ebel and I immediately feared for Ebel's life. Kumanjayi starting to stab Ebel in the chest and neck area. If the court accepts that in the instance as described, Kumanjayi was, when Constable Rolfe had reached down for his Glock, he realised that Kumanjayi's left hand was already on his Glock. Is it consistent with the training of Northern Territory Police to twist your hips back, knock the hand off your Glock, step back, and then at that point he draws his weapon and fires?
No.
Why not?
Well, as I touched on earlier, we train in firearm retention, and stepping back, twisting your hips is part of that, but keeping the gun in the holster is the training, so that's where it's least risk to yourself or anyone else, is if you keep it in the holster.
So you would knock an offender's hand off your weapon area and then make sure that your gun was properly secured and stayed in its holster, correct? Yeah,
so the acronym for that training is GUN, which stands for grab, undo, neutralise.
Undo, neutralise.
There was much said in the committal and the trial about the police being trained on edged weapon equals gun. In terms of shots 2 and 3, you still, in spite of the fact that Constable Rolfe was presented with an edged weapon, say that those 2 shots were inappropriate and excessive. Is that right?
Yes.
And is that because the circumstances did not justify it at that time?
Correct.
For the first time at trial, you got to hear Constable Rolfe's explanation as to why, in his mind, shots 2 and 3 were justified. Mr. Strickland, in cross-examination, for example, at page 1175, said, while Kumanjayi was on the mattress and before you fired your shots, you couldn't see Kumanjayi's right arm, could you? And Constable Rolfe said, I could. Mr. Strickland says it was under his own body, wasn't it? And Constable Rolfe says, incorrect. He goes on to say, well, Mr. Strickland says, if you couldn't see Kumanjayi's upper body moving, could you, before you fired the shots 2 and 3? And Constable Rolfe said, if you count his right arm as his upper body, I could see that moving. So he maintained that the right arm was still moving and therefore was still capable of inflicting injury on Constable Ebel. Do you accept that as a possibility?
Not in the position that they were in.
So you maintain the evidence that you gave in your statements and at trial that the second and third shots were excessive,
Yes,
and that there were other options available at that time.
yes.
What were they?
I had Rolf holstered his firearm. He had all the other accoutrements available, and empty hand tactics, assisting his partner with controlling Kumanjayi with empty hand tactics.
And did I understand your evidence earlier to be that in terms of the risk to Constable Ebel, because Constable Rolfe couldn't predict how Constable Ebel was going to move his own body at that time, not appreciating that the shot had been fired, he could have placed himself in a situation where he was shot?
Yes.
I want to ask you, I've only got a couple of topics left, about something referred to as DIAMO plus P. It's referred to in paragraph 130 of your statement from the 13th of March. DIAMO plus P model, as you outlined there, is taught to police as a model that sums up the elements in considering whether the use of lethal force is justified. The model means D for defence of life, serious harm. Are police in a position of defending life or at risk of serious harm? Does the threat presented have the I, intent to carry out the action, A, ability to carry out their intent, M, means to carry out their action or threat, O, opportunity to carry out the action or threat, and P, precluded of all other options? Is there no other option available to police to resolve the incident less forcefully? Is that model of a way of training police how to think in terms of assessing a threat?
Yes.
And is that acronym something that was used while you were teaching police?
Yes, it's been used for quite some time.
Regardless of the particular acronym, is it standard training? That is it consistent with broader principles?
Yes, and it's still in the manual.
And it's still in the manual?
Yes.
That acronym or the training principles?
The training principles.
So that acronym is now no longer used, is that right?
Yes, it's been taken out of the manual.
But the training principles are exactly the same?
Yes.
Just want to show you a memo which was sent by Superintendent Scott Pollock, who for a period of time was the officer in charge of the Charwell Coronial investigation. This is a memo dated the 20th of October 2020. It appears at 5-60 of the brief of evidence. Have you had an opportunity to read through this memorandum, Superintendent?
I don't think I've seen this before. I'm not 100% sure, but I don't think I have.
I just want to ask you about a suggestion made by Superintendent Pollock about the use of that acronym. It's just at the bottom of that page 1. He expresses some concern in this memorandum, which is sent to Commander Proctor, about the use of the DIAMO plus P acronym. He says an issue of obvious concern is Barham's reference to a police use of force training acronym DIAMO plus P. Officer Barham has relied heavily on the acronym in determining that Constable Rolfe had not adhered to elements when considering whether the use of lethal force is justified. And he notes that you've dedicated 5 pages of your statutory declaration to that in determining that Constable Rolfe did not adhere to the DIAMO plus P training he received while under recruit training. If you turn over the page, it suggests that Superintendent Pollock suggests that when that fact was raised, that is that DIAMO plus P is no longer used, you provided a further statutory declaration suggesting that only the acronym DIAMO plus P was removed from the training content and that the elements were still contained in a facilitator guide. Further research, according to the then Superintendent Pollock, now indicates that DIAMO plus P was a training reference licensed to verbal judo. That ceased being used by Northern Territory Police Force as a training mechanism in 2007. And at that time, because of copyright, the acronym was removed, and you should have been aware of that. just putting that to one side, and that can come down, does that change in any way your opinion with respect to the options that Constable Rolfe had available to him with shots, in avoiding shots 2 and 3?
No, not in any way.
Finally, officer, I just want to remind you of the comments of Constable Rolfe in the spotlight video that we saw. He says towards the end of that particular frame, he got tripped up, meaning you, he got tripped up some point after he started making those statements. Medical evidence has come in that has shown the first shot was not incapacitating in a medical sense. I'll just pause there. Does it affect your opinion in any way that medical evidence shows that the first shot would not have killed or incapacitated Kumanjayi?
No.
He goes on to say, and in fact, the second and third shots were not incapacitating to Kumanjayi's right arm. Does that affect your opinion in any way?
No.
Do you maintain your position that your view of the body-worn video shows that Kumanjayi's right arm must have been pinned under his body?
Absolutely, yes.
And do you understand that to be consistent with the evidence of Constable Ebel?
Yes.
He goes on to say, so I believe along the way he's changed his story, and I think he was just willing to toe the line by the executive, and it all got a bit sticky for him, and he was out of his depth. Did you in any way change your story to toe the line by the executive?
No.
What do you think of that suggestion?
No. Belongs with other conspiracy theories.
In terms of your role in this court, you are being called as an expert witness, correct?
Yes.
You understand that as an expert witness, it's your obligation to this court above other obligations you might have to the Northern Territory Police Force to tell the truth?
Yes, absolutely.
And to be objective?
Yes.
And to analyse any new material that comes forward to see whether or not it changes your opinion?
Yes.
And you don't take a side in these proceedings, do you?
No.
You're not against Constable Rolfe, are you?
No, I don't recall ever meeting him.
And you're not for any particular party in these proceedings?
No.
Do you say to Her Honour that you have at all times attempted to give evidence in a fair and objective way?
Absolutely, I have.
I won't ask you to go into details about it, but after you gave evidence, or I would draw that, even during the trial, was it the case that you were subjected to adverse comments?
Yes, from certain parties.
And after the trial, did some of those adverse comments continue to be directed to you?
I object to this, and as this relevant, you can't possibly assist Your Honour at all. I mean, this really is extraneous to cause the circumstance of death.
Dr. Dwyer?
Your Honour, the relevance is how this Northern Territory Police Force recovers in terms of morale and caring for each other in the wake of this tragedy. It is my submission that a number of witnesses who gave evidence in the trial have been subjected to abuse on social media and in some circumstances face to face, which is completely inappropriate and not in keeping with a police force that works together to protect members of the public. And that it's important that they develop strategies to find ways to move through this and to learn to support each other if they are going to be an effective force to work together as a team to serve members of the community.
And if members are willing to speak independently and objectively of their opinions without feeling that they might be intimidated after the event.
Yes, Your Honour.
So it goes to the very heart of being able to investigate independently.
Yes, Your Honour.
Your Honour, and in particular, any communications to this witness before he had finished giving his evidence during the trial. So there was a conversation alleged to have occurred by this witness, which was revealed in the trial, that there was an approach by Richard Rolfe to him before he had finished his evidence, and that's particularly important.
No, it's not. And that's a side collateral issue which was emphatically denied by Richard Rolfe at the time. That's a contest that Your Honour can never resolve, and there's nothing whatsoever to do with this inquiry. I quite understand Your Honour's point a moment ago in the exchange that you've just had with Dr. Dr. Dwyer, but that's a very different category what my learned friend's talking about.
Yes, and I don't think the timing of anything is particularly relevant to what I said. At any stage, police should feel that they are able to give honest, objective opinions and feedback during the course of an investigation.
No argument from me about that, Your Honour.
And for that reason, I'm going to allow
If Your Honour pleases.
You were the subject of abusive and derogatory comments on social media, is that right?
Yes,
And you were prior to giving your evidence?
yes,
And you have been since giving your evidence in the
Yes.
trial and
Yes.
prior to coming to give evidence today?
yes, abated somewhat.
Has that, and in fact you were sent something in the mail which was derogatory and inappropriate as well after giving your evidence, is that right?
Yes,
And has that in any way influenced the evidence that you're prepared to give in this court in a fair, independent and objective manner?
no,
Those are my questions.
Mr. Mullins.
Oh, I beg your pardon. Just before Mr. Mullins, Your Honour, I just might note that we have a senior Mbartwe custodian in the court, Elaine Ngware Peckham, and I know the court would welcome a senior Mbartwe custodian in the court. We are grateful for the presence in this court, and it honours the court, and I want to acknowledge that.
Thank you, Dr. Dwyer, for bringing that to our attention. Mr. Mullins.
Thank you, Your Honour. I'll be 20 minutes, so I'll be
Thank you.
done by 1. I will be referring to document 10-04 and starting at page 14, please. Superintendent, my name is Mullins. I appear on behalf of the Brown family. In the statement that you prepared for the purposes of the criminal trial, you make a reference to the circumstances in which it's appropriate for a police officer to discharge a firearm in a particular situation. If we can pull up that page 14, please, and it's paragraph number 31, just so we can review it precisely. You say, the rationale behind police discharging a firearm at a human being is that there is such an overwhelming need present to stop that person immediately and prevent them from continuing with the actions that they are presently engaged in, that a firearm, an option of lethal force, must be deployed. And then you say that the need must be so great that it justifies the potential to cause serious harm or death to the offender as a result of the shooting, to the preclusion of all tactical options. So the need you're referring to there, if it was on a scale, is at the very top of the scale. That's correct?
yes,
And so the need is one that must be overwhelming. That's
Yes.
right? And it must be present at that current time.
yes,
Onto the next page at paragraph 34, you then say, a police officer resorts to the use of a firearm when they assess that their own life or the life of another person is at stake. Now, when you refer there to they assess, you are talking about a subjective element. That's correct?
yes,
That is an assessment by the individual police officer that either their own life is at stake or the life of another person. That's right?
yes,
And you add that if the situation is so serious that an offender must be shot, then it should be done in such a manner that the offender's actions are discontinued in the shortest possible time. And you go along to describe that the primary goal is to incapacitate the person. That's right?
yes,
Now, at paragraph 19, and we don't need to go to paragraph 19, but you identify that Constable Rolfe exercised his right to silence. That's right?
yes,
And at the time you were preparing this statement, you say, Rolfe has not provided what his apprehensions and beliefs were at the time of firing the shots and has exercised his right to silence. Therefore, I am unable to consider these mental elements and about the necessity and proportionality of the force used in this situation. So is it correct to say that even though you emphasised in paragraph 34 the importance of that subjective element, when you came to prepare your report, you couldn't rely upon an assessment of Constable Rolfe's subjective element because he hadn't given his evidence, or he hadn't given an explanation as to what he had done?
Correct.
All right. Now, can I just explore with you for a moment the interface between what I might call that subjective element and the objective assessment that you did based on the body-worn video and other material?
Sure.
You understand that? You understand what I'm saying? You've carried out what is effectively an objective assessment by looking at the body-worn video and what was happening at the time and making a determination whether that was a reasonable use of force. You with me?
Agreed.
So there's an objective element to this and a subjective element.
Yes.
All right. Now, let's take a couple of examples. Assume we have a particularly anxious police officer who sees a person holding a butter knife and he's at a distance of about 10 or 15 metres, and he decides that person's a risk to him and to shoot. All right? Now, the officer might say, when he's being investigated, that he thought that the offender had the ability, the means and the opportunity to cause him a serious injury, and that his life was effectively at stake. You understand what I'm saying there?
Yes.
So subjectively, it may be that he holds that belief.
Yes.
But objectively, you determine that's not a reasonable use of force.
Yeah.
That's right. Now, you would conclude in that situation that it is not a reasonable use of force because of the objective element demonstrating that it's not.
Yes.
All right. Now, take another example. A police officer is 1 metre away from an offender, and the offender has secreted a flick knife, and the police officer doesn't know that. So he secreted it in his hand, and when the offender's later interviewed, he said, I was going to use it on the officer and slash him. In that situation, again, the police officer shoots because he believes that, for whatever reason, he's the same particularly anxious officer, that there might be a problem. Now, from the subjective sense, there is, subjectively, he holds a view that is not that he thinks there's a reasonable risk of death or a risk of death. Is that right? He doesn't see the flick knife. He doesn't know that the man holds a flick knife. You follow me?
Kind of.
Right. Objectively, when one looks at the situation with what one knew afterward, there was a significant risk, wasn't there? Potential. Now, in that situation, if the objective is present but the subjective is not, you would still say there's an unreasonable use of force. Is that right?
To shoot him.
Yes.
Well, you have to assess all of the circumstances.
Can we accept that neither will necessarily be determinative, and that one has to look at all the circumstances in the particular case?
Yeah, I accept that.
But when you've gone through your assessment in respect of the second and third shots, you can say that objectively, from what you can see, the use of force was excessive.
Yes.
And you don't need the subjective assessment to assist you with that, because objectively, the test is proved or satisfied.
Yes.
But when it comes to the first shot, the situation's different, isn't it? Because you say, well, objectively in respect to the first shot, I think that the use of force was not excessive. Or not justified.
My actual words are, with all circumstances considered, minus Rolfe's mental element, that there is a scenario open in which firing that shot was reasonable.
Correct. Can we go to paragraph 128 of the statement, please? It's
13th of March.
yeah, 13th March. It's 10-04. It's page 34. And if we just scroll down to 128, please. And we can see there, it appears to me that Rolf fired shot one in defence of Ebel. In line with training to have drawn and fired his firearm, Rolf must have formed the belief that death or serious harm would result to Ebel. So you're making an assumption there that based upon the objective material that you have seen, that Constable Rolf did have a particular state of mind.
Yes.
And you set out in the paragraphs below the various factors that you rely upon there. Number one, prior knowledge that Walker had armed himself 2 days prior to resist arrest. Roman numeral 2, Rolf had seen a bladed weapon in Walker's hand. Roman numeral 3, Rolf had actually been stabbed by Walker with that improvised weapon, the logical extension of which is that if Walker was prepared to stab Rolf, he was prepared to stab Ebel. Roman numeral 4, Ebel was in close physical contact with Walker, who was still armed. And am I correct to say, in addition to that, he also had the arm unrestrained in respect to the first shot?
Yes.
Which was what was different in the second and third shots.
Yes.
Kumanjayi Walker's, arm was restrained. Romeo 5, police training around the potential lethality of edged weapons, particularly when in close proximity. And Romeo 6, such close proximity means there is not time or distance in which to consider and deploy other tactical options. Now, in the page that follows, can we just go to page 35? You then apply the Diamo plus P model that you have already been referred to by counsel assisting. And if we then go through to the next page, which is it's at page 36, you say at paragraph 135, the next question to ask is, did Walker have the opportunity to stab Ebel? Given that Ebel was in close physical contact with Walker and that Walker's right arm was not restrained, there was opportunity for Walker to stab Ebel. Now, you say there, from your reading of the body-worn video material, that you understood that Kumanjayi Walker's arm was not restrained at the time of the first shot?
His right arm was not.
His right arm, that's right. And as a consequence of that, you say that Constable Ebel did not have Kumanjayi Walker under control.
Yes.
Now, if you just assume for the moment that contrary to the objective evidence, that Constable Rolf in fact did believe that Ebel had Kumanjayi Walker under control, would you agree that that element is not satisfied?
If Rolf thought in that standing position that Ebel had the right arm under control,
That's right.
then potentially it would not have been justified.
Because your conclusion is really based only on the objective evidence. You don't know what Constable Rolf actually believed, do you?
No, I don't.
And it's the case, isn't it, that if the coroner ultimately found that Constable Rolf did not believe that Constable Ebel's life was at stake, such that there was an overwhelming need to stop Kumanjayi Walker, you would agree that the use of the firearm for the first shot was not a reasonable use of force?
If that's the coroner's finding, then yes.
Yes. Thank you. Nothing further. Thank you, Your Honour.
Yes, I note the time will take the lunch break.
All stand. The court has been adjourned.
We'll return at 10 to 2.
Ah, yes, thank you.
You know what?
I might take the last one.